An injunction filed in Tokyo District Court threatens to erase a game played by 25 million people. Not monetary damages, market annihilation. When Nintendo and the Pokémon Company sued Pocketpair Inc., they weren't just protecting patent rights. They were aiming to neutralize a rival that had captured a massive audience seemingly overnight. The lawsuit targets specific patented gameplay mechanics, creature capture systems, combat mechanics, and mount riding features. Patents aimed at dismantling an entire game from the inside out. For Pocketpair, this is a fight for survival against a corporate titan. For Nintendo, a calculated maneuver to reassert dominance over a multi-billion-dollar franchise. The ruling will determine whether a successful game, and the community built around it, can be litigated out of existence. The legal assault is not aimed at character designs or branding, but at the abstract logic of gameplay itself. At issue are 3 specific Japanese utility patents. These documents do not protect the image of a creature, but rather the underlying algorithm for interaction, a system where a player's input launches an object, which then interacts with a target entity to produce a specific state change, such as capture. This is the legal equivalent of patenting a recipe, not the final dish. The claims also extend to the functional mechanics of mounting and riding in-game characters. Critically, Nintendo and the Pokémon Company did not simply enforce pre-existing patents. They employed a deliberate strategy of divisional applications, a series of amendments and continuations filed after Palworld's January 2024 launch, deriving from parent patents dating to December 2021. This process allowed the claims to be retroactively sharpened and tailored to target Palworld's specific mechanics. Unlike a copyrighted model or a trademark name, a utility patent on a game mechanic grants exclusive rights to a specific interactive solution. It constructs an invisible moat around a method of play, a legal barrier that competitors may not see until they are accused of trespassing. This strategic sequence raises a critical question of timing. Why did the legal challenge not arrive until September 2024, months after Palworld's launch and after the very patents at issue had themselves been registered? 8 months. For 8 months, the market rendered its own verdict. After its January 2024 early access launch, Palworld achieved a velocity rarely seen, accumulating over 25 million players. That period was not just a commercial success. It was an operational stress test, conducted in full public view of the industry's dominant incumbent. Pocketpair expanded, its player base solidified, and it operated with no legal friction. To the developer, and to the world, Nintendo's silence felt like tolerance, an implicit green light. That interpretation was nullified on September 18, 2024. Nintendo and the Pokémon Company filed their patent infringement suit in Tokyo District Court, converting presumed acceptance into direct legal warfare. The public statements were dueling narratives. Nintendo asserted a solemn duty to protect its IP. Pocketpair claimed it was unaware of the patents, framing the lawsuit as a strategic ambush. And the initial damages sought were nominal, a fraction of what the case was truly about, a figure that was almost beside the point. The nominal sum was a feint. The true target was a far more permanent remedy. A court-ordered injunction. The period of trust was over. The filings now alleged a specific, traceable transgression, not of style, but of substance. A patented gameplay logic, allegedly copied line by line. The implicit partnership of inaction had been broken. What happens when 8 months of passive permission are revealed to be just a loading period for litigation? The allegation is not one of artistic theft, but of functional duplication. In court, the plaintiff's case would be built on a claims chart, the forensic equivalent of an X-ray laid over 2 skeletons to prove they share the same bones. It maps Palworld's interactive systems directly against the specific language of Nintendo's patents, line by line, step by step. The first alleged infringement centers on a precise sequence. A player aims, throws a spherical object, and that object initiates a probability-based capture event upon contact with an in-game entity. Nintendo, alongside the Pokémon Company, argues these specific technical systems for creature capture and mounting are not generic game concepts, but proprietary methods protected under Japanese patent law. A second core claim isolates the logic for mounting a rideable character. The specific system for transitioning a player from a ground state to a mounted state and the associated combat mechanics constitutes, in Nintendo's view, a patented invention. Under this pressure, Pocketpair was forced to act. While publicly contesting the validity of the claims, the company implemented targeted changes to specific gameplay mechanics, such as how pals are summoned and how gliding is performed. Not a subtle patch, a visible alteration to the game's fundamental loop, the equivalent of rebuilding the engine while the car is still moving. An attempt to engineer around the patents while the case proceeded. Pocketpair's challenge was no longer just about winning in the marketplace. It was about surgically altering its own creation to escape the precise language of the patents. And this is where the case stopped being about one game. This specific line-by-line dispute then rippled outward, escalating into a multi-front legal war where the stability of Nintendo's patents themselves would be challenged on a global scale. While the Tokyo District Court prepared for litigation, the foundational pillars of Nintendo's case began to fracture, not just in one courtroom, but on a global stage. First, in October 2025, the Japan Patent Office rejected a related Nintendo patent application. A clear signal. A vulnerability exposed. Then came the seismic event. In April 2026, the United States Patent and Trademark Office issued a non-final rejection of all 26 claims in a core U.S. patent covering similar summoning mechanics. These were not case dismissals. But for Pocketpair, they delivered something priceless. Powerful external ammunition for their invalidity defense. For the first time, neutral, expert examiners had publicly stated that Nintendo's core innovation lacked a genuine inventive step. Citing prior art and tests for obviousness, these offices provided Pocketpair with an official, third-party critique of the very weapons being used against it. The narrative in the court of public opinion, and potentially in law, shifted. It was no longer just about whether Palworld copied a mechanic. It became a fundamental question. Were Nintendo's claimed inventions ever truly patentable? Nintendo's offensive strategy was instantly forced to evolve into a defensive war on two fronts. They must now prove infringement in Tokyo while simultaneously fighting to save the validity of their patents in Washington. This created a high-stakes stalemate. As of this reporting, the Tokyo case is deadlocked. No trial date. The injunction hangs in limbo. And with the core logic of its patents publicly questioned by two major patent offices, Nintendo's leverage in any future settlement negotiation is significantly weakened. Regardless of the final verdict, the scars from this confrontation are already etching a new map of engagement for the entire game development industry. The lawsuit, intended to end a dispute, instead engineered a stalemate where both sides began to bleed. The very act of war became a strategic liability. Pocketpair was forced to make surgical, non-market-driven cuts to its game. Two core mechanics were reportedly altered under the direct threat of a judicial ban in Japan. Their creative vision was compromised not by player feedback, but by legal fear. Meanwhile, Nintendo's aggressive strategy invited devastating scrutiny. In October 2025, the Japan Patent Office rejected a related Nintendo patent application, a direct challenge to the foundation of its case. Then, in April 2026, the U.S. Patent and Trademark Office issued a non-final rejection of all 26 claims in a core Nintendo summoning patent. The plaintiff's own arsenal was being publicly dismantled by the very offices that granted it. This created a precarious equilibrium, a mutual assured destruction of legal and creative capital. The Tokyo court has no verdict. The injunction is in limbo. And with its patents now questioned globally, Nintendo's leverage is significantly weakened. The precedent is clear. Suing for patent infringement can inflict catastrophic collateral damage on your own IP portfolio. The chilling effect radiates outward from this deadlocked battlefield. Every developer in the creature collection genre now maps an invisible layer of risk. It's not just about avoiding similar-looking monsters. It's about avoiding similar-feeling interactions. The throw, the capture, the ride. A hidden web of patented systems lies dormant, ready to be activated. A clear partition is now required between a playable mechanic and a legally defensible innovation. The industry is learning a brutal lesson. Survival depends not just on creative iteration, but on a preemptive legal strategy. You must be prepared to challenge the validity of an incumbent's patents before they can be weaponized against you. The architecture of your game's legal defense has become as critical as its code. As the Tokyo court remains silent and patent office rejections continue to mount, the software world is left with a defining question. Is patenting a core play interaction, the simple, repeatable loop that defines a genre, truly the guarding of a unique invention? Or has it become the erection of a toll booth on a public creative highway, designed not to foster innovation but to tax it?